I'm going to quickly introduce our panel members. Um, Judge Jean Schneider is the supervising judge at Kings County Housing Court. And prior to that, she sat in both Manhattan and Bronx County. And she'll tell you that she was the first judge ever to have a volunteer lawyer for the day program in her courtroom. And prior to that, she was a legal services attorney, right? Legal services attorney for a number of years. We won't even talk about how many years, because she and I started together. Judge Peter Moulton is currently the administrative judge for the Supreme Court of New York County civil term. Prior to that, he was a civil court judge here in this building. Sitting next to, and before that, he was with Judge Leland DeGrasse as a court attorney and with Corp Counsel. Paul Alpert is a Bronx civil court judge, and before that, he was a housing court judge assigned primarily to the Bronx, I believe. And before that, he was a court attorney to the Honorable Walter Taub. And at the end is a non-judge, but an important person for this panel. This is Mike Williams, who works quite closely with the Access to Justice program, but he's the borough chief clerk for the Bronx Family Court. Before that, he was with the Brooklyn Court as a clerk. Is that fair enough to say? Okay. All right, Jean.
Yeah.
A few years ago, I asked you to come up to my office. And other than thinking you might be in trouble, tell us about that conversation and your initial thoughts.
Okay. Fern mentioned that I was, I'll confess it, 20 years a civil legal services lawyer before I became a judge. So perhaps it will not surprise you that when Fern called me in and said, so we have this volunteer lawyer for a day program and I want to put it in your part, I was, I guess the right word to use is skeptical. Yes. And probably I was bold enough to express my skepticism. I should probably also disclose that during those legal services years I worked in programs that gave advice only and that ghost wrote pleadings for people that we did not represent. So I had some experience of less than full representation. But I really wondered about this. I believed, and I still believe, that full representation is the gold standard, that people with unlimited resources choose full representation, and therefore that ought to be what we're trying to get to, period. That said, in the court that I work in, the housing court, although there have been any number of exciting developments recently that are expanding access to full representation for people without resources, we're not there yet. And my experience with the volunteer lawyer program was and is an entirely positive one. I think the most important thing about the program, the thing that makes it successful, is that each project, each location is supervised by an experienced housing lawyer, and that person does triage at the case intake point. Cases that are too legally or factually complex or require a more complicated approach to the litigation to serve the person are not taken in. They are instead referred to a legal services program that can provide better representation. And the experienced lawyer then is also available to the volunteers to supervise, to answer questions, to review agreements and and other documents, and to keep things on track. The most impressive thing to me about the program is the way that its clients responded to it. The people that were assisted in my courtroom, and since I'm now supervising, I still supervise a court in which volunteers are operating. The folks that have a lawyer with them, you can just tell, take a certain amount of confidence from that, are more willing to speak up and to raise issues. It is a court, those of you who are not familiar with it, it is a court in which almost every tenant appears without a lawyer and almost every landlord appears with a lawyer. And so it is difficult when one entire side to litigation feels voiceless. And I think that the volunteer lawyers give a voice. The program has evolved over time so that it now does follow cases from court appearance to court appearance, and I think that's an improvement. It is also better when volunteers participate repeatedly, when they develop some expertise and come back. And we've been fortunate enough sometimes to have volunteers who came back. The other thing that's sort of hard to calculate about it, but that I think is a real benefit, is that it affects the atmosphere of the courtroom. So the fact that there are lawyers speaking for some tenants in the courtroom affects the other tenants in the courtroom. People see a different vision than they see in a court part in which all of the tenants go up alone and speak in front of the judge with a landlord's lawyer. So that I think it actually affects the entire court part, not just the individuals who get the assistance. And I have really appreciated that.
Jean, let me excuse me, ask you a question. Some studies have shown that moderate income individuals are looking for limited scope services in order to, one, keep their bills down, but people are just, more consumers, and they're very careful about their pockets these days and skeptical about the legal profession as well. There are working poor and moderate income people appearing in housing court, correct?
Yes, absolutely.
All right, and more
on
so,
both sides.
On both sides, all right, on both sides. And so the owner's side as well as the tenant side is in need of legal services, correct?
Yeah, in Brooklyn, where I'm sitting now, there are an increasing number of property owners who are coming to court without counsel. And those folks do sometimes hire somebody to prepare their pleadings and then come to court on their own because they don't want to pay more. Or sometimes the reverse. They'll fill out the papers themselves and then they come to court and discover that it's a little more complicated, and they hire somebody for a couple of court appearances and then maybe not after that.
Okay, so when you say that full representation should be the standard, will you allow for the fact that there's a group of individuals in the country who really want limited scope services and only want to hire a limited scope attorney?
I think that's probably true, but I think it's related to resources. In a world of unlimited resources, I'm not sure that would be true. Actually,
there sometimes no. Wayne, do you want to say anything about that in terms of your practice? Do you have people who can afford full services who come for limited scope?
Well, in my practice, no, because there's a flat fee price.
Okay,
So that I paid my fees up front.
Okay, Laura? Where's Laura? Laura? Are all your clients who can't afford full representation?
No. Most of my OAR clients can afford my regular fee. Typically not
All right. Peter, tell us about your experience as you were the supervising judge of New York County Civil.
Well, after the 2008 financial meltdown, there was a huge increase in cases involving consumer credit in all our civil courts, and I can see a number of judges here who sat in parts that were devoted simply to consumer credit, and that's why I'm speaking today. In 2010, I took over that part. It was assigned to a single judge at that time because it was so, the numbers were so overwhelming. And I would conference cases, my law clerk would conference cases, and these are all cases where the defendants owed debt, usually pursuant to a credit card agreement, sometimes pursuant to a student loan agreement. Very small amounts, but they were crushing amounts to the defendants. The plaintiffs were all represented, of course, usually by per diems who were there for various companies that purchased debt. Occasionally, the initial issuer of the debt, such as Chase or some other bank, would have an attorney there. The Attorney for a Day program was a real godsend. The cases were very similar. The defenses were absolutely similar. As the judges who sat in this part know, frequently the purchasing of the debt was very poorly documented, and that could make for a fantastic defense, a complete defense for a defendant. The assignments, in a word, stank, usually. So if you were a defendant, you could say, this assignment doesn't show that this company purchased this debt, and therefore, Judge, you should dismiss my case. But nobody coming to court knew that. None of the defendants knew that. And I'm a judge. I'm a neutral. And it's a very fine line that all the judges in this room have to walk as to how much of a heads up you can give someone that they have a viable defense. Really, you can't. So the Attorney for a Day in our court was very good at explaining to the defendants their defenses in these cases and what their shot was at winning a case or what their negotiating leverage was. And actually, frequently, not frequently, but in many cases, I wouldn't say a majority of the cases, but in many of the cases, the defendants appeared in court and said, Judge, I lost my job. I want to pay this debt. I admit it's my debt. And so really what happens then is a negotiation. And most of the cases ended in a negotiation, if not a dismissal. But when the defendant showed up with knowledge of their defenses, of course, they were much better armed to go into a negotiation. And that's where the Attorney for the Day came in. And it was Mr. Adedeji. I don't know if he's here today.
Ade was here.
He was terrific. And he was also very good at training the other lawyers for the day. And we also had law students doing this, and that was, I think, a very good thing to do for law students from area law schools to see that law is not always practiced in elite settings, and that there's a large population of people who are under-lawyered. So that was another advantage. I completely agree with what Jean said about the other people in the room would be educated by the initial conferences, and they would see the lawyer for the day advocating for the defendant, and they would learn about the case on the spot. And also seeing that it was a more level playing field, not a completely level playing field at all, but a more level playing field, I think was also psychologically useful to the defendants. Of course, I don't know that firsthand. That's just my impression. So it was a terrific program. I think that we'd had a consumer credit part prior to the 2008 meltdown, and there was no lawyer for the day. When did it begin, Fern? I forget.
2009.
2009. And so I sat there just as a random civil court assignment before I had it as my only assignment. And you could see the imbalance of power. It was clear. And I think Lawyer for the Day did a very good job of leveling the playing field.
Well, now, you wear well, let me ask you one question, then I'm going to ask you another question. If we could facilitate more lawyers in the consumer credit part who perhaps are being compensated in a practice model, would that assist the court?
I don't see how it could hurt. Justice Kennedy's here today. I know that the numbers in the consumer credit part mercifully have gone down, that there's not quite the same volume. Isn't that right, Judge Kennedy? She's affirming that. So I'm not sure there'd be as much business, but I think certainly it couldn't hurt to have compensated lawyers in there as well.
Now, let's put your hat on as now the administrative judge of the Supreme Court. Can you envision where limited scope lawyers could be useful in the Supreme Court?
I'd say mostly in ghosting. Certainly, we have a help center, but it's sort of overwhelmed at 60 Center Street. But plenty of Article 78s could be better written by pro ses. I got an amen.
I heard some amens from the
Yeah.
crowd. Okay.
And I'm sure there are other types of papers that would be
What
would
about
benefit.
what about in the matrimonial part? Do you see any role for limited scope practitioners in the matrimonial part?
That's a very good question. I really don't know that much about how the matrimonial part is. I'd like to hear what you have to say about that.
Well, for example, in the matrimonial part, the preliminary conference can set the tone for the rest of the divorce. What if someone would like to bring in an attorney just for the preliminary conference to make sure that the temporary maintenance, the initial visitation, some of the issues are fleshed out? Do you think that would be helpful to matrimonial lawyers, matrimonial judges?
We have, I started a matrimonial committee at 60 Center Street, and that's certainly something we could bring up. I'd be interested to hear what the practitioners would say as well.
Are there any matrimonial practitioners here? Okay, raise your hand.
What you were saying, I have clients contact me, and one particular client, I don't want to lose.
She has clients contacting her. I'm just repeating for Albany.
Yes, she doesn't have a lot of money, and she's being abused by her husband, but the husband filed for divorce, and she wants to hire an attorney for that day. And, an attorney would know upon the preliminary conference whether it will be filed, promotion, open the integrity for the husband to be an attorney. But if she cannot, if the attorney is afraid that she could not proceed after the preliminary conference,
To withdraw.
the attorney might not want to help her.
Okay.
And
So if you had, in this client's case, if she just wanted you to come in for the Potente Lite conference, preliminary conference, I apologize, you would be interested in representing her just for that?
Yes.
Okay. All right. Okay. Anything else in the Supreme Court that you could see some use for? Article 78 is clearly. Foreclosures?
Certainly in foreclosures, there are a lot of pro se
And just for the
defendants.
settlement conference?
Yeah, and there's, of course, the mandatory settlement conference, which we have in front of a JHO, but I'm sure that those would be enabled as well by...
Does anybody here do foreclosures? In a private practice, not in pro bono? Okay, so there might be some usefulness in limited appearances just for the mandatory settlement conferences in foreclosures.
Mhm.
And consumer credit cases to the extent that they do exist in Supreme Court?
Mhm. I
Perhaps
think
as well?
absolutely.
All right. Okay. Paul?
Hello. Last time I sat in this courtroom, there were 100 angry tenants staring at me, so it's nice to be, I see some friendly faces out there, so that's nice. I guess I'm the only one up here who's had the opportunity to sit in two volunteer lawyer for a day parts, because I was the Bronx pilot program when it started, and I'm also sitting currently in Bronx Civil Court.
It says Bronx Housing.
Bronx Housing. And
So tell us about both experiences.
I'll just tell you how you notified me of it. When I was asked to be or told to be the Bronx volunteer lawyer for a day judge, I basically got, Paul, you are the Bronx volunteer lawyer for a day judge. And I basically said, does that mean more work for me? They said, no. I said, I'll take it. When I was elected to civil court, I got a call from Judge Fisher, I need to see you. I said, what did I do now? I got elected, really, like 10-year term, please. And when I entered her office, she said, I have good news and bad news. The good news is you're going to stay in Bronx County. I said, yay, I live in the Bronx. The bad news, you're going into consumer credit. And it didn't turn out to be bad news. My experience with the volunteer lawyer for a day has been generally positive. Expanding on what Peter said, from a judicial standpoint, because we're giving you our point of view, it takes us off the hook. I see a lot of my housing court friends out there. Very often in housing court, because we're dealing with so many pro se's, we are treading that thin line between being a judge and being an advocate. The volunteer lawyer for a day takes us off the hook because we have that individual who's there, who's going to give that defense to that person, who's going to give that advice that we sometimes have to bite our tongues because we can't and we shouldn't start to advocate for one side or another. Housing court created some problem because housing court is hyper-technical. And if you're going in there without the proper training, being a volunteer lawyer for a day is not useful because there are a lot of nuances. And if you're not familiar with those nuances, you are not giving good advice to your client. With the proper training and the proper time, yes. Consumer credit is a different animal because consumer credit, straight contract, basically, for the most part. There are some nuances, but for the most part, the consumer credit, when they come in, the lawyers, everybody knows basic tenets of evidence and contracts. It's something we all learn in law school. We don't necessarily get that training for housing unless we have been trained in housing or practice housing. So it makes it much more difficult, I think, for someone to take on that role in a housing context. Now, as a judge, what we want to do is settle cases. And the volunteer lawyer for a day, perfect for that. I mean, we need that buffer sometimes. We need somebody sometimes to just hold somebody's hand and say, listen, this is what can happen, this is what might happen. Judge doesn't want to do that necessarily because I don't want to be in a position where I'm beating somebody over the head and saying, look, you better settle this case because if you don't, this is what's going to happen. All of a sudden, well, Judge, why are you prejudging it? Why aren't you listening to me? If they hear it from one of you or from a volunteer lawyer or for that lawyer for a day, it makes my job a lot easier. Settlements go much smoother, I've noticed, in the consumer credit part when we do have the volunteer lawyer for a day. And they do, as Peter said, get cases dismissed. And if a case has no merit, it should be dismissed, right? And that's what should happen. Not necessarily by the judge, who should not advocate, but by a lawyer who is giving advice to a client and saying, look, I don't think they can make their case out. I don't think you should settle this case. And that's the proper thing to do. The problem with that is when we go to trial. Because now we're standing at trial and that volunteer lawyer for a day is not there.
All right, Paul, how many cases are actually tried in the consumer credit part?
I've had several where that's happened. Not many. Not many, because it doesn't pay to try the cases. But we've seen it, I've seen it 2 or 3 times where people have said they don't want to settle or they've been given the advice, rightly so, not to settle, but could not articulate to me the proper objection or the proper motion to dismiss, or were even able to question a witness. So it becomes a problem if we have to move beyond a settlement or a preliminary stage.
With respect to housing, is it helpful if, and we're only referring to pro bono programs now, not the paid model, is it helpful that the types of cases are triaged so that the basic housing cases are handled?
Yeah, certainly some of the more onerous holdover cases, certainly if you are not a trained practitioner, the person should not be handling that
Does a
type of
volunteer
case.
lawyer for the day program, Gene, do any holdover cases?
No.
Right, I know they're only doing non-pays, but it should not be expanded to a holdover unless that person has
It
that
won't.
particular
Right.
expertise. But as far as, yes, in a typical landlord-tenant setting, where there's just an issue of how you're getting the rent or how you're going to pay this rent and negotiating a stipulation that's
Or
not
repairs.
onerous.
Or repairs.
Or repairs.
Or repairs, yes. It's very effective.
All right, so I want you to sort of imagine, Paul, a world in New York where there are limited attorneys who are paid. Do you think that that would help in housing court?
To some degree.
Okay,
To some degree, and again, if it's limited to a certain class of case.
okay. All right, so, and I'm pushing you here, obviously. Are all the lawyers that do full representation that are paid, I'm not talking legal services people, I'm talking about paid people, are they all, all good?
No.
Okay, all right. So it would be the same problem regardless of whether it's limited or full.
It would be, but you know what? If I'm walking into an office and I'm paying you, I would hope that you would vet the person that you're hiring.
Again, do people pay for full services and end up with lawyers that are,
They do.
okay.
Yeah.
So I think the answer is that we should train all lawyers in
Yes.
substantive areas,
Yeah.
whether they're full or limited. Can we agree on that?
Yes.
Okay, so given that, and maybe the court's interested in doing that, or bar associations interested in doing that, imagine a world now where lawyers can go in the housing court in a limited appearance basis. Would that make a difference for individuals who are not eligible for legal services?
Yes.
Okay. Thank you. Pull up. Mike, tell them who you are, what you do, and why you're here. 'Cause I know because I told you, but that's other than that.
I'm Mike Williams. I'm the Borough Chief Clerk for the Bronx County Family Court, and I'm here to talk about my experience with the volunteer lawyer project in the Family Court. I remember when we started it years ago, there wasn't a volunteer lawyer project in the Family Court, and
You put it closer.
there wasn't a volunteer lawyer project in the Family Court. So we got a little group got together. Barbara Mulet's here; she was part of it, and we had some law firms saying, "Is there a need?" So we did a little day in the life of Family Court, and what we did was just write down a couple cases while we were preparing it to show the attorneys of cases that happened. And anybody familiar with Family Court, we have some tragic, sad stories. I mean, I remember one of the stories that we told people was a 17, 18-year-old girl came in to file paternity for a child against her uncle, because the uncle raped her on their family reunion trip as he drove her down south, and none of the family believed her, and her own parents were fighting with her. Yet she wasn't entitled to an attorney prior to this, or a grandmother filing for custody of a 14-year-old child who was recently arrested, but his mother was murdered and his father was incarcerated for life, and not automatically entitled. So, I mean, there are scary things. I mean, besides the multiple DV aspects of a family court. And that's every day. You'll find cases like that in family court. I work in the Bronx family court. I'm not sure if everybody's familiar with the Bronx, but if I asked, the majority of people here probably do not know the poorest congressional district in the United States. The poorest congressional district in the United States, according to the 2010 U.S. Census, is the South Bronx. The 17th congressional district is the poorest in the entire nation. We walk around here as New Yorkers with chips on our shoulder thinking it's the greatest city in the world, which it is. But I don't think we'd be proud to say we host in this city, in this great state of ours, the poorest congressional district. Most of us think it's West Virginia, Louisiana. It's right here in New York City. And there are pockets of that poverty levels that's going on in South Bronx throughout every county in New York City. There is a drastic need for this service. These people come into our courts. We file in the Bronx, we filed approximately 58,000 filings last year. The New York City Family Court as a whole is the busiest family court in the nation. Majority of those filings, all petitions, about 97% of the petitions, 95% of the petitions are filed without the assistance of an attorney. Non-agency filings, the custody, the child support, visitation, multiple paternity, guardianships, they're all filed without the assistance of attorney. And I remember when we got together, Bill Silverman, who recently moved over to Proskauer, right? Very nice. Amazing Bill Silverman was part of the team that put this together. And the one comment he said, he remembers he's seen a group of attorneys argue over a sentence in a paragraph for a week in a document that was 500 pages long, right? Yet litigants that may not be from this country, may not speak English, right? Different culture, basically come into a courthouse and file for custody of a child, to provide a child with the stability and safety, the most important decision any of us could ever make in our lives, right? And they come in and they just walk up to a non-attorney, tell them what they want, either given a piece of paper to fill out or assisted in some manner, but never speak to an attorney and face an attorney alone for the most important decision. And usually when they see a judge, it's the first time, it may be for just a couple of minutes. So this program, like Harana stated earlier, it changed the atmosphere in the courtroom. Well, it changed the atmosphere and culture in our courthouse. Family court still needs, to go far. But if you've seen the family court 10 years ago, when there was no volunteer lawyer project, oh no, it's 10-year anniversary now, I think, for family court, 11 years ago. If you've seen it, it's changed drastically, the culture. It's become much more user-friendly. The need is out there, and more importantly, like I said, you know, in the Bronx, 52% of the people speak a language other than English, you know? Bronx also has the largest percentage of children, largest number of children out of the 4 counties, even though it's only the 4th largest borough in population. It has the most children under the age of 18. We have a very young county for the most part. So basically, I mean, they come in and they're filing these cases, never to see an attorney, quite often victims of domestic violence or for some, you know, poverty at home or some issues at the house. To give these people the dignity and civility of being able to sit with an attorney, there is no greater thing we can do in a courthouse. This is not a service to these people. This is a need, you know? Although we talk about it as a service, and I'm hearing this limited scope, bundling, unbundling, it doesn't matter to us. And it doesn't matter to that litigant that walks in, that 19-year-old from South America, holding 2 babies in her arms with a black eye and having to explain that over a counter to a clerk, you know? I mean, there's nothing sadder than that. To have the ability to say, you may want to speak to an attorney. You know, we have an attorney here for you today. There's an attorney here to talk to you. Just to give somebody, especially somebody that's not familiar with our justice system, not familiar with our country maybe, or language, just to give them that opportunity to sit in a decent area and explain themselves to somebody that's going to listen to them and give them 45 minutes or a half hour. I mean, like, I can't state it enough. I mean, you know, in family court, quite often we deal with life and death issues, or the stability and safety of a child in all circumstances, whether it's domestic violence or poverty in a household. You know, the custody of a child can, again, be the most important decision we can ever assist with. So, I mean, that's the need of the Bronx. The impact it had is, like I said, the impact is that it changed our culture a lot. It not only seeing that, even for clerks, it took a burden off clerks, it took a burden off, you know, judges and magistrates to have somebody with it, but the most important impact it had was to that litigant, because that litigant that often would walk out the door when they got confused because the signage was awful, nobody was assisting them with their language, or whatever it may have been, to give those people, those families in crisis, those people in need, the opportunity to speak to an attorney. The most important thing it really did was give them the confidence that they can get through this, the confidence to go through the proceeding, the ability to enable them to say, yeah, maybe I got a chance here, maybe this court will help me. That is the impact, and that impact is as strong as any impact you could ever have in a courthouse. I mean, so, I mean, basically, that's the impact it had on
Mike,
us.
can I back you up just
Yes.
a bit? You mentioned quickly that having the limited scope attorneys in the health centers helped the clerk's office. Tell us how it benefits the court, not the judge, but the back office operation and the clerks to have lawyers in the courthouse.
You know, in New York State for paternity, just for a quick example, paternity, right? We all know it. I say paternity, it's somebody filing for a petition of, you know, a petition to establish paternity over a child, and name a father, the parent of a child. All right? A lot of times, paternity can be very complicated, and we talk about it. So the best thing about paternity, and I always say this, right? So when that 19-year-old walks in, or 25-year-old walks in that doesn't speak the language, and we have to tell them, they say they want to name a man the father of the child. So basically, we got this thing called equitable estoppel, which is like, scares the hell out of attorneys, never mind a layperson. So if somebody comes in and they were previously married in South America, but they left, or whatever country, and they left to come to this country, we tell them as clerks, or in the forms that we have to give them because the language requires it based on a form, that, well, you're going to have to file a paternity petition, but since you were married to somebody where you have no idea who he was, there's a presumption of legitimacy, right? Based on that presumption of legitimacy, equitable estoppel may apply, right? In order to file paternity, in order to get an order of affiliation declaring this new person the father of a child, right? So nobody understands that. I mean, so when they come in with difficult, complicated questions like that, or service issues, which is a major thing, you can't get jurisdiction without service in the family court. You're not going to get that child support. You're not going to get that custody or order protection. Comes in and they have those complicated cases for a clerk to say, look, that's beyond my scope. I'll refer you over to an attorney to sit with you that can explain service or equitable estoppel. you know, or some other Latin term that we forced to use still, you know what I mean? But basically, you know, I mean, that's the greatest need. And that allows us, I mean, granted, some people come in, they know what they want, they've been there before, they come up and we can, you know, they do it. But every day we have these difficult cases. And honestly, we don't have enough. We have the Volunteer Lawyer Project 2 days a week, but we could easily use it more. I mean, we could use it 5 days if it were allowed.
So the burden of dealing with confused litigants gets shifted on those 2 days to the lawyers that are sitting in the courthouse.
Right, and even on days where some people come in, they'll be told, you know, today's Tuesday, but if you can come back Thursday, we'll make an appointment and you can speak to an attorney about it. So, I mean, it's not just that day. We'll tell people they can come back on a different day and try to hold it, especially for certain cases. And there's so many complicated issues, whether it's interstate child support or custody or visitation and estoppel issues throughout.
So Paul and Jean and Peter, you might not know the answer to the question because you're on the bench most of the time, but as the supervising judges, you might be able to answer it. Is there a difference in the hallways also because there are more attorneys?
Absolutely. There's
Absolutely.
absolutely a difference in the hallways. And I think that the housing court hallways are one of the most difficult things for us to figure out how to manage, because the judges are in the courtroom, and we know that all kinds of stuff goes on in the hallways that it's very difficult for us to get a handle on. And I think that the presence of additional advocates in the hallway certainly affects how the litigants that the volunteer lawyer is helping are addressed and treated in the hallways, but it also, I believe, affects the atmosphere of the hallways because I think that people, first of all, I think that there's the effect of other litigants listening in and hearing a back and forth that educates them about their own ability to respond and speak up. But also, I believe that others who are regular practitioners in our court modify what they're saying when they're in the hearing of other people who might speak up.
I think that the hallway is not as big a problem with the consumer credit parts because there's always like 2 per diems who are there for every single case, and therefore they have to be in the courtroom doing work, so they're not outside trolling for cases or trying to influence defendants.
Paul, anything you want to say about that?
One of the things, I know petitioners' attorneys, maybe and plaintiffs' attorneys kind of push back against these kind of services, but one of the things I've seen is that at least they have an attorney to speak to, and a lot of times in housing, you have an agitated tenant, and you just can't get through to them, and sometimes having that attorney there, it makes a big difference to have somebody in between that you can at least talk to and explain something to, and it does kind of tamp down stressful situations, especially with as repetitive cases where that tenant's been in that court before.
Well, the ethics rules prohibit the opposing party from saying anything to the other unrepresented person other than you should get a lawyer. So it does help to have an attorney. Okay, I don't know if you were here during the lunch session, but it was expressed by both judges and by practitioners that judges often don't want to let lawyers out of the cases, so that letting a limited appearance lawyer go might be very difficult. So I know, Paul, that you have expressed concerns about them not being available for trial, but you have any suggestions?
I let them
Anything you
go.
can say?
No, I'm not going to force. I mean, no, I'm not looking to make enemies with all these guys or anything. And I understand it's a difficult situation to be placed in. I don't really want to put someone in that position, especially when they're volunteers, to have to go in and do something that they feel that they can't do to the best of their ability.
Would you feel any different if they were paid for a limited appearance? Would you let them go?
I think if you're paid, again, once money starts changing hands, I think it's a different animal. I really believe
The
that.
client only wants to pay the litigant for the first appearance.
And after that, they want to get out?
And there's a retainer agreement that says it's just for the first appearance.
I don't have a problem. That's a contract you've entered into with an attorney. I have no problem letting him out at that point in time. It's not for me to say that you should be forced at that point to represent, especially if you're not getting paid.
Judge Cohen?
Yeah, I guess this gets back to the same issue I brought up before, which is how, sort of an adjunct to it, which is how do we now treat that litigant? Do we treat that litigant as pro se, or unrepresented? Do we treat that litigant as represented for the things they agreed to when they were represented and unrepresented at other times?
Yes.
We have, again, as I can speak to housing, we do sit in Part 52, the commercial L&T part, and we have real issues with people who have retained counsel, not limited scope counsel. They retain counsel and then they come in and file, we do call them still pro se orders to show cause, unrepresented orders to show cause. Then they show up on the day of the court appearance, and you say, well, you're listed here, I have you listed as having an attorney. I can't hear you without your attorney present.
Well, that's not a limited appearance, so the attorney should be.
I understand that, but my concern is essentially the explanation that we usually get back, which is, well, my lawyer knows I can't afford to pay him for every appearance, so when I've got some money, I'll pay him to come in. When I don't have money, I don't pay him to come in, but I still need this order to show cause.
Okay,
And
that's what I would say. No, actually, that's by fly, limited appearances. I'm going to turn to Laura. Laura, who's a practitioner, for those of you who just came in. You are representing a family court client, and the only issue that you're handling is child, what did you call it, parenting plan? The parenting plan. That's all your client is interested in. The judge and or the opposing attorney wants to talk about child support. Is that something that's reality would come up in your practice?
In my practice, probably not, because I likely wouldn't separate them if they couldn't be separated.
Okay. All right, equitable distribution then. How about that?
If I'm not representing them for the equitable distribution part, again, I don't think those matters, because when you're before a judge, I don't think it's easy to say, Your Honor, I talked to my client about the money piece. I wouldn't separate those.
Right.
I don't think in practice it can be separated. So typically, if I'll file a limited notice of appearance, it will be for the event itself. And whatever is involved in that event, I will handle.
Okay, when you say the event, you're referring to a court appearance?
I'm referring to a court appearance.
All right, but the court appearance is about the parenting plan. But what comes up is the judge raises it or the other side raises it. How do you handle that?
I'm not here for that. It's not before the court. And the judge simply wouldn't deal with it.
But
because again, if I'm there, for instance, temporary orders that relate only to a parenting plan, then it wouldn't be before the court, and I think it would be reasonable for me to ask that it not be addressed on that day.
So were the judges in Massachusetts trained on this limited appearance venture?
Yes.
Okay.
Yes, I understand that I don't know if
Judge Fine's not here anymore, but
they were all trained on limited assistance representation, so they understand exactly what happens. And I would say, in my experience, talking with some judges, just the feedback I get from the Bar Association and various committees I've been on, the judges love it. It's really been, even those who are initially a little reluctant to embrace LAR, they've loved it because it takes away some of the responsibility or the burden having to deal with unrepresented people who don't understand exactly what's happening, can't necessarily break down the issues before the court. So it's been very good for the judges. I can't recall hearing anything negative from any of the judges.
okay. So are some of Judge Cohen's concerns addressed by training the attorneys on how to communicate with their clients so that the client understands what the limits of the representation are? And is that one way of addressing?
Absolutely, but that's part of, everybody has to be certified that it's available, if person is available And it's only about 2 hours, but most of what it does is talk about communication and how to get across to the client, potential client, what the limited scope may be. And all the paperwork that's involved, it's not required, but I encourage people that I'm talking with to use it. It is a further backup on understanding what the limited scope may entail.
So clear, limited scope retainers.
Absolutely. And then I also wanted to comment, somebody mentioned earlier about notice of appearance and the notice of withdrawal. On the proposed, again, it's not required in Massachusetts, but it's on the website, and I think the best practices would have you use the ones that are on the website, the notice of appearance and the notice of withdrawal. Both require the client to sign as well. So it's yet another opportunity to explain this is what you're signing, this is why. After today, I'm not representing you anymore unless we re-engage. So we sign a whole new agreement letter.
Okay, and I might also tell you that the volunteer lawyer for the day program in New York City, if the lawyer wants to come back, because some lawyers do get hooked and they want to come back, they have to sign a new retainer. Judge Schneider, and then I think we have to break in 2 minutes.
Judge Cohn brought up another area where it could be useful, being the Part 52.
A commercial.
Because you have, these are all mom and pop businesses that they're capital.
Okay, for those of you who are not in the city of New York, Part 52 is the commercial landlord-tenant part in the city of New York.
So they get sued as a corporation, which under the statute, they have to have a lawyer, and they can't afford a lawyer, but they're also sued personally. So you're in this, it's a mess. It's a mess. So I usually tell them, go out and settle the case, I'll sign off on it. You can't settle it, you gotta get a lawyer, otherwise there's gonna be a default taken against your business.
Okay, I have time for one more comment or one more question.
I have a question.
Identify yourself.
Sure. I'm Jennifer Brown. I'm pro bono counsel at Morrison and Forster here in New York.
Thank you.
And we are participants in the family court volunteer program. The attorney for a day is always interested in what is the training for the lawyers, especially keeping in mind that story none of us want to be part of.
The consumer training is different than the housing training. They're trained in substantive law as well as the ethics of limited scope representation. And there's a panel coming up, and they'll tell you how long the training is. The volunteer lawyer program, which is advice only, is longer actually because they sit in the help centers and they get everything possibly coming in, through the door. Than the volunteer lawyer for the day training, but the volunteer lawyer for the panel will address those issues. Okay, we're going to switch panels now, and after this panel, you get sugar.